Seen a lot of change, been through a lot of pain. Some things are not the same as they were a year ago, but all will be okay. I move on each and every day. The past is where it stays, way back a year ago. I've changed.
Good morning, good evening, good afternoon, wherever you are, however you are, whoever you are, and welcome. Let's hope today's the day. I'm fearful that they forgot to put ink in the printer, or their dog ate their homework, or whatever it is, but hopefully we'll get jury instructions this morning, and then we'll go on verdict watch. On verdict watch, instead of me sitting here paddling for I don't know how long it's going to be, I'll probably yeet all of you over to Dave's channel. He's just started covering the Crumply case. Very interesting case. Is the parents guilty by proxy because of their son? It's a very, very interesting case. Could be groundbreaking. So instead of me just filling dead air, you could get well, I'm not calling him the best YouTube lawyer, but the best Michigan lawyer I know. At least top 5, 10. You can go and hang out with him. I might join him on his stream. And then when we have a verdict, I'll be coming back and showing that. I might also be looking into the Turtle Boy. He is in trial right now. Normally they don't televise that. So lots of stuff to happen, lots of cases to follow, as always. And to the nice person who went into my 2-month-old video and implied I'm racist, thank you so much for watching my video. It's always nice for the constructive criticism. And the nice guy over on Rumble who doesn't like my style, I'm sorry, this is my style. And no, I'm not thinking this pro se Tyrone Tucker is guilty. I just said he talks himself into a prison cell. So, but thank you so much. You were very reasonable in your criticism. But sometimes you get good criticisms, and sometimes you get crime spies to show up. Thank you so much, crime spies. And Iris, the lovely Iris. Wolfram, not as lovely, but still very happy to see him. M. Young, always nice to meet you. See you. Well, I made it high class. I'm sorry. I made it a little fancy. I didn't put in the prostitution ring. I know. I have made certain creative freedoms. My pal, how are you doing? And the lovely reindeer. I feel like I will be bouncing back and forth all day. Well, that's why I think instead of just trying to split the vote, that's because there's a vote going in the US. I know you're saying that. I thought I could just shut down instead of sitting here paddling, filling air. So I'll bump you all over to David when we have the jury instructions, and then hopefully you'll come back when we have a verdict. Or else I will still do it. Flash fan. No, that's not Flash. I am great. I hurt my back yesterday doing calf raises. Don't ask why. I'm just an idiot. Peter A., how are you today? It's still not televised today with Turtle Boy, right? Well, Jamie is somewhere. I believe I've sent her a link, or else she's normally in chat telling me I forgot to send her a link. I sent her a link yesterday. She's out working, I bet. Stephanie, how are you doing? Cool Gamer. Good morning, Rossman Ranch. You have so many things to say, but you can't type so much. Well, are you going to call me racisms too? Hopefully not. Leslie, how are you this morning? Well, in Denmark, we have a saying that there's more a-holes than bakers, and that's why there's more shit than there's cake. MLS had said the Beat Gym interview last night. Yeah, for those of you who don't know the Zachariah Anderson case, please join up over on MLS and watch. That lady, oh, I know now why I'm perpetually single. It's in fear of meeting a lady like her. Not as lovely? No. Well, I just like it when you use that vanilla scented shampoo. I'm too cool. No, not today. I'm not cool today. I'm actually a little hot because I got angry when I read people calling me a racisms. No, Jamie isn't tired of this trial. Jamie, I don't even know. Maybe she's hanging out with Dave. I don't know. Jamie is Jamie is a rolling stone. Wherever she streams is what she calls home. I shouldn't make up songs. She isn't a lady. She is trash. I wouldn't even call her trash. That'll be. I like to go to the dump and throw out trash, and I'm not sure we could even incinerate her without blowing up the entire plant. Why isn't this trial starting? The anticipation of the outcome of this trial is killing me. Yeah, again, a halfway decent lawyer would have gotten a directed verdict. I would think, well, no, we know judges don't like to give them, but if we ever saw a case where that could be the case, this is it. Absolutely no evidence of him doing it, other than a guy who admittedly took a plea deal because he was afraid to stay in prison for life. And watching his interviews again, now we watched them back yesterday. To me, it's pretty clear he's not coached as much as he picks up the correct signals and says the right stuff. So yeah, Jamie is not on David's stream. Well, she had a lot of computer problems yesterday. What is going on here? Do ever I lay my head is home?
Oh. Okay. Yes, sir. Let me go ahead and push play.
What?
Every story, and you should never judge a person based on one version of the story. That no matter how thin you hold piece of paper, there's two sides to the paper. So I'm going to tell you what I have so far on the side of the story that is not in your favor. And then give you an opportunity to fill in the gaps, correct any misinformation you think we may have, and tell you the side of the story. Because this will be tonight your first, last, and only chance to give us your side of the story. Because beyond here,
Always.
how do you know how it works? Attorneys get involved, and then attorneys tell you not to talk. And that's why I'm trying to talk to you. Yeah, so.
Hello, Penella. Welcome.
Otherwise, I would have been like, man, if I thought I needed an attorney, I would have been like, look, I need a lawyer. You know what I mean? But I know I haven't done anything, you know?
It's his interview with, I think it's the lady officer, way thinner than she is now. But why? I don't know. We came in with him standing by the TV. We have no explanation.
Anyway, but
Okay,
give
so
me your side.
I'm gonna let you know a couple of things.
I'm doing swell.
Detective picture is absolutely accurate with the timestamp on the video. We have you on video
No,
walking on.
this is him playing something for the judge, and I don't know why, because Law and Cock started a little bit late. I don't know why we're seeing this, because we should be at jury instructions right now. Yeah, there was a lot of echo over at MLS. Hopefully they'll fix it. No, this is court. So let's see what happens.
Second Street, from where you live, toward Local Avenue, which is the road that the Treehouse is on. 8:11 p.m. At 8:15 p.m., the first call comes into 911, telling our dispatchers that a guy has been stabbed, he's dead, and he's laying face out in a pool of blood. Hear me out. So you have 4 minutes from where you're at to where this thing happens. Now, the really disconcerting part of all of this is at 8:19, 4 minutes after we have a report of a man being killed, we have you and Rory on video walking back from the Treehouse toward.
That's gotta be impossible though, because, okay, you know, like I said, man, for him, I wish I could try this, because man, for him, again, man, go back and check the times on video. Because that had to be somewhere around the same time. Had to be. You know what I'm saying? Because man, for him, you know, I remember man, for him, the whole thing with the police lights and stuff like that, but not long after we went and got cigarettes. So man, for him, man, how could I be man, for him, Tom's on buying cigarettes while I'm supposed to be over there at the CVS? You know what I'm saying? Now, I do know, like I told him, man, freaking, I have a vague memory of man, freaking walking through the drive-through at the CVS.
Okay.
You know, so man, I may have gone there earlier, man, freaking, I could see that, you know, but I would know I didn't go there later. I know I didn't go there later, but man, freaking, I may have gone there earlier. But man, I mean, literally check the video, man.
Okay. Now, I'm going to tell you some other things that the detective picture hasn't shared with you, that I'm going to share with you. That's on our side of the story. In the walk from Laurel Avenue on 2nd Street to where you live, we found in lot 72 a knife. Okay, on that knife is blood, and on the handle of that blood, latent DNA. That's going to the lab. Okay, and a little further up the road, in the back of a boat, parked alongside 2nd Street, is a mask. And the mask has very weird, freaky, scary face on it, but it's also made out of foam, and on the front of the mask are 3 blood smears. And the mask has a really nice elastic band that goes around the back of the head.
No, we are watching a video. We came in the middle of it. It's his police interview. I think it's to prove what he said, that he knew from the detective that Matt's blood was on the knife. But we haven't got an explanation. We came in the middle of it, and we don't know what happens.
And a nice foam pad in the front, it's loaded with DNA. Okay? Now, all that stuff's gonna go to the lab.
Cool.
Okay?
I'm confident.
Okay?
Totally confident. You know?
And we have wounds on our victim that are consistent with the knife that was found in lot 72. So what
We're trying to listen to
know
everything.
is
Thank you.
that the story and the details of the story are not stacking up in your favor.
Well, I'm just saying, all that stuff that you just told me, test all you want.
Okay?
You're not gonna find anything there for him, with my, with anything lying on it. You know, I mean, granted, you know, if the mask came from the house, man, it might have a fingerprint on it, man, who knows, I may have touched it. Same thing with the knife, man, I may have touched it. But I guarantee you, man, freaking, you ain't got no DNA, man, for no man on the inside of that mask, and there's no man freaking, I never here now, so. You know, I mean, the timestamp with the video, I mean, like I said, definitely coaching. That's all.
Okay. So I'm trying to understand the exact nature of your verbal tennis motion.
Well, Your Honor, the blood, she tells me that there's.
Now, what is it that you're asking me to do?
I would ask this, Your Honor. I mean, because again, to be fair, and like I said, to make sure that the jury has the right information, I would either ask that the video be allowed to be back with the deliberations, or that Your Honor, instruct the jury.
Okay, so I don't see a problem, but we'll hear what the state's.
But there is no inconsistency here. What we argued is genuine. We argued that he wouldn't know it's Matt Bonnet's blood on the knife. They simply identified the evidence that they have. He deduced that it was Matt Bonnet's blood and told Paulo Belmonte. This video is not evidence. We haven't contradicted anything in evidence. We made argument. So I would submit to the court, there's nothing here to rule on other than nothing, really.
Your Honor, if I might. No, they said this was their single most compelling piece of evidence, that there was no way I could have known.
Okay, but stop
And yes.
it. Get to the point that somehow or other they were misrepresenting the state of affairs because they knew that someone had told you that it was Matt Bonnet's blood and they intentionally misrepresented that? Is that what you're claiming?
Yes, I am saying that.
Well, that video doesn't establish that.
Honor, I definitely could infer from what she just told me that was Matthew Bonnet's blood. If it's consistent with the knife wounds, if again, they have blood on the knife, then it only, it only stands to reason that it's Matthew Bonnet's blood. I mean, again, they're purporting that conversation to be something that is totally evident that I had to be there. And they said there was no possible way for me to know. Well, yes, there is.
Okay.
Yes, with just a few seconds.
I'm denying the motion. I find that the information conveyed to the defendant during the Penny Phelps interview is not inconsistent with the state's argument. There was mention of blood found. It was, in fact, I believe there was indication it was going to be sent for testing, but it was never told to you, oh, that's Matt Bonnet, that's Matt's blood. It was not. So anyway, Mr. Tucker, I've made my decision. I recollect that, no, sir, I'm not going to argue any further. I've heard your motion. I've made my decision. I allowed you to, when the state objected during closings, you're right, they can't use something as a sword and a shield. That didn't come in because of the interview, the statement, because it's a prior consistent statement, basically, that's inadmissible. But when they objected and you started to talk about this particular interview, I overruled the objection and said that you could mention that you were at the station for a long period of time and questioned about the event. So I allowed you to make some explanation. I didn't allow you to go into what was said, but yes, sir.
For those of you who just stopped in, he played a video of his interview from the police station where they tell him we found a knife with blood on it, because he believes that the state misrepresented it when he said he told Paula that the knife was with Matt's blood on it, and he could only know that if he had been at the scene of the crime. The judge denied it, said you are allowed to talk about what you that you had been in an interview and had certain something told to you. But he denies the motion to either correct the state or give the jury the video back with them. This hasn't been entered into evidence. It hasn't been played in court. So yeah, there's no reason he should have it in with him. But again, object to this, and there's a possible for appeal.
You haven't.
I'm not trying to argue.
Well, that's what you're doing. If you had a question about my ruling, that's fine. But
I do.
Okay.
I'm not trying to argue.
Wilson, what's your question?
No. Yes, I know that Your Honor overruled their objection.
Right.
You did establish that I could talk about being at the station. I could not talk about what the hearsay would have been if what I was told.
Yeah, then he should have done.
I mean, it
Yeah.
is very, very, misleading. to the
Congratulations,
jury
27
To
years.
allow them to go back there and deliberate on something that could cost me my life
Mhm.
based on, information that, again, they're not being provided the entire amount of information concerning what the major part of their case is.
Okay, I understand your position. I've denied the Ori Tennis motion for finding no violation, allowed the video to be played in the record, allowed the Ori Tennis motion, heard substantial argument, made a decision, provided rationale to support the decision. Understand you disagree with it, understand you've preserved the issue should it become necessary, but in any
I'll go
event.
ahead and take the video off of it. Yeah.
Okay, I don't mind.
Oh, I hope he gets an easy go around with it. Mine took 3 months to get over. Well,
I saw Kerry in here. Did he want to come in here, or could we ask?
I understand why he wants
it
it played, because
I saw Kerry, and there was some question about
the way
the operation.
the way they inferred it was he couldn't have had that knowledge without him being at the scene. But it's logical to infer when he knows Matt was killed with a knife, and we found a knife with blood on. A reasonable person would surmise that that blood would be from Matt. That I find that reasonable for him to believe that. Oh, you're a little hit. Well, we can skip if nothing else happens. Yeah, maybe we can just go live. Yeah. So I maybe he should have argued it better, saying, well, I was told so and so.
This person did, but they have a different name than on the document. So.
I imagine we'll be around.
Okay.
So, yeah.
Okay, do we have all the jurors
He preserved it for appeals.
present?
Your Honor, the only remaining, I guess, issue is the unbolded
Oh,
3.10. It's really up to the defendant and the court. I just did it in.
well, it's fine. It's with me. We mentioned the,
No, as long as it's the same
Yeah,
document.
it's the same one here. Same document.
which number is it?
If you tell me, yeah, you were at the treehouse where Matt was murdered, and we found the knife with all the blood on it. Would you logically infer that the blood would be Matt's, or would you say it must be Pixie blood? Or how should I know it was Matt's blood? It's a reasonable assumption to make that it would be Matt's blood. Yeah, that's why, again, I think a reasonable lawyer could have gotten him off with a direct verdict, even though judges hate to do it. And even after after he finished his closings, and he put forward the motion again, I think a reasonable lawyer could have talked him out of it.
Same package.
Yes, I don't need a whole new package. I already got this
We
one
are all
completely
confused.
organized.
We still haven't read through the
Well, let me look.
jury instructions. They were sitting here till late yesterday. They're totally reasonable.
That's-
It's the same if I told you, oh, I have a big bump in my car, and you hear my car was near a place where another car was hit, you might say, well, he must have hit that car. I might have hit something else. But it'll be logical to assume that it was my car who hit the other car.
I apologize.
I don't know if all the brackets is out, but they should be out. They were working till at least 3-4 o'clock yesterday.
Okay, that is in lighter
So
tape
stupid.
type, consistent with the type of the other
The attorney,
instructions. So I'll
withdrew when he
substitute the
didn't
one
want to
that's
take the plea
darker
deal.
for the one that's lighter. It says the same
Lovely
thing. Thank
Kim.
you.
Good morning.
Let's bring the jury. in,
The other
please.
Kim Farringham, all the Kims. Yeah, he should have argued stronger in his closing arguments about that, because they went straight up there and said, well, no way he could have known that. Jamie, you missed the show. Yeah, but he had an attorney, and his attorney quit because he didn't take the plea deal. Stop smiling. But I still
I've been
think
watching.
a reasonable attorney could have gotten him off. Well, Pekka, that's the fun of
Thank you.
following multiple
Please be
times
seated,
trials at a
everyone.
time. Well, Jamie's, I don't know if you saw it, he tried to play his interview from the police station where he was told about that they have found a knife covered in blood to say it's reasonable for me the next day or whenever he met Paula to say the knife had Matt's blood all over it, because the state really heavily leaned in on that, say there's no way he could have known it. But again, that's correct. I'm going to turn you down, Jamie. You are hot as
Coming in hot.
always hot. I'll put you to 55%.
Okay.
But a reasonable person, if you were told Matt got stabbed, we found a knife with blood on it, most people would think it must be Matt's blood. So yeah, but he could have brought that up during closing. So yeah,
Yeah, I
bring
was
all the
watching
things to the
it.
stream. Yeah, so I understand it, but now it's preserved for an appeal. I think that's smart of him, even though I still believe he should be let go.
Good morning. Good to see you all here again this morning, members of the jury. So, yesterday you heard closing arguments. And I told you that in light of the hour and the like, that it seemed to me to make more sense to send you home for the evening, to take care of the business that we needed to take care of, and to have you come back this morning so you could receive jury instructions and have ample time.
Yeah, but he was allowed to
for your
talk about some of it.
deliberations.
But yeah, he couldn't go into
And so here we
details
are
because
to do that.
because that
So
would be
I'm going
hearsay.
to
But
now
I think it's
instruct
very
you
smart of
on
him
the
to
law
preserve it for appeals.
applicable to the case.
Hello.
I'm going to use this packet of written instructions, basically verbatim. When you go back to deliberate along with the
I think
evidence, you're going to have this packet
if he had
of
had
instructions.
at least a
Exactly what I'm
co-counsel,
using to instruct you.
that was a
So you'll have
big
both the
opportunity the
verbal
judge would have let this
instructions
case
and the
go.
written package.
I kind of felt like he
Members of the
inferred that
jury, I thank you
yesterday.
for your attention during this trial. Please pay attention to the instructions I'm about to give you. Franklin Tyrone Tucker has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Franklin Tyrone Tucker, the defendant in this case, has been accused of the crime of first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, number one, the defendant intended the crime to occur, and number two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree felony murder and second-degree murder, it is not necessary for the state to prove the defendant intended the death of Matthew Reed Bonnet. It is not necessary for a principal to know every detail of how a first-degree felony murder second-degree murder, robbery, aggravated assault, or battery will be committed as long as the principal intended the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur, and did some act or said something that was intended to help and did help the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur. To be found guilty of a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery, as a principle, it is not necessary for the state to prove a defendant knew another participant of the first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery while armed. Franklin Tyrone Tucker is accused of first-degree felony murder in count 1 of the indictment. First-degree murder includes the lesser crimes of second-degree murder, manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Reed Bonnet was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree felony murder or second-degree murder, or whether the killing was excusable or resulted from justifiable use of deadly force.
This is the big
The
problem.
killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant
Thank you,
was at the
Deepest.
time of the killing.
Oh, I
The
can see
killing of a
rumble
human
rants
being
over
is
here now.
excusable and therefore lawful and under
Welcome,
any one of the
welcome, Deepest.
following 3 circumstances. Number 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and in misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Franklin Tyrone Tucker may be found guilty of first-degree felony murder or any lesser included crime. To prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Matthew Reed Bonnet is dead. Number 2, while engaged in the commission of a robbery, Franklin Tyrone Tucker caused the death of Matthew Reed Bonnet. Number 3, Tyrone Tucker was the person who actually killed Matthew Reed Bonnet, or Matthew Reed Bonnet was killed by a person other than Franklin Tyrone Tucker, but both Franklin Tyrone Tucker and the person who killed Matthew Reed Bonnet were principals in the commission of robbery. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. Prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number 2, force, violence, assault, or putting in fear was used in the course of the taking. Number 3, the property taken was of some value. And number 4, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim, when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist.
And another thing is, if you have lesser included, if you have someone who is leaning kind of guilty, not guilty, you can always say, well, we're just going to give them a lesser included, like they did with Karen Thala, costing her 14 years of her life in prison.
The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist in any particular extent, to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that the knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. Counts 1 and 2 are linked in that the crime charged in count 2, robbery, is an essential element of the crime charged in count 1 of the indictment, first-degree felony murder. You should first consider the evidence applicable to count 2. If you find the crime in count 2 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. If, on the other hand, you find that the crime charged in count 2 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1. A guilty verdict on count 2 does not require a guilty verdict on count 1. You should find the defendant guilty on count 1 only if you find all the elements of that crime, including the essential elements contained in count 2, were proven beyond a reasonable doubt. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of first-degree felony murder is second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Matthew Reed Bonnet is dead. Number 2, the death was caused by the criminal act of Franklin Tyrone Tucker. Number 3, there was an unlawful killing of Matthew Reed Bonnet by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. And number 2 is done from ill will, hatred, spite, or an evil intent. And number 3 is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death.
It's on vacation.
Excuse me. prove the crime of robbery, the state must
That's the
prove
way we do it in
following
Denmark,
4 elements
one at a
beyond
time.
reasonable doubt. Number one, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number two, force, violence, assault, or putting in fear was used in the course of the taking. Number three, the property taken was of some value. And number four, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear. An actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction.
Rosebud.
An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. If you find that Franklin Tyrone Tucker committed robbery, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried a knife, you should find him guilty of robbery with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Franklin Tyrone Tucker committed robbery, but you are not convinced beyond a reasonable doubt that he personally carried a weapon, then you should find him guilty only of robbery. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. Number 1, Franklin Tyrone Tucker intentionally and unlawfully threatened, either by word or act, to do violence to Roger Allen.
Thank you so much
Roggett.
for popping in chat. We love to have new people in chat.
Tucker appeared to have the ability to carry out the threat. Number 3, the act of Franklin Tyrone Tucker created in the mind of Roger Allen Roggett a well-founded fear that violence was about to take place. And number 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Roger Allen Roggett may be found to have been in fear. An actual fear on the part of Roger Allen Roggett need not be shown. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Franklin Tyrone Tucker actually and intentionally touched or struck Roger Allen Roggett against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. If you find that Franklin Tyrone Tucker committed crimes charged, you also find beyond a reasonable doubt that Franklin Tyrone Tucker was personally wearing a hood, mask, or other device that concealed his identity, you should find Franklin Tyrone Tucker guilty of crimes charged while wearing a device that concealed his identity. If you find that Franklin Tyrone Tucker committed the crimes charged, but you are not convinced beyond a reasonable doubt that he personally wore a hood, mask, or other device that concealed his identity, then you should find the defendant guilty only of the crimes charged.
Just make a short stop here, just so we can breathe and let it sink in. I wouldn't find him guilty of any of those charges.
No.
The mask haven't been proven. They never found that Jägermeister thing, that he was carrying a knife. We were told he was carrying a pipe when we heard from Travis. Well, I've been bitten by a bad jury before. I know it's a crazy case, and I know that personally I don't like him. I think he's an a-hole, but he shouldn't be found guilty in any of these charges. But I'm fearful just because you have the lesser included, they will find him guilty in some of the lesser included. That's my gut feeling right now. You bet this pray to go the right way. The buffer system is real, and it seems to get but my problem is the jury has the state has a conviction rate in 95% of their cases because people forget everyone is innocent until proven guilty, and most people say, "Well, you must have done something since you're here," and I know that's a bias you have to fight because again, I've been doing it for 12 years, and the first time you see someone with fuck the popo on their knuckles, you think he must be a bad guy, but you still have to see the evidence.
Absolutely.
Yeah, it's lesser included. I don't like them. Make the jury prove him guilty or find him guilty in the worst of it. Yeah, I think so. So thought of crack pipe. Yeah, that would make sense. We don't like. Please hit the like. Yeah, the state is trying to pile on charges to get him convicted of anything they know their case is weak. Yeah, and again, I always get nervous when we get here because the jury is a fickle mistress. Hello, C-Star.
Sure is.
Yeah, Recovery Addict have been really nice to me and recommended me a lot, and I like a few of his people coming over here, and hopefully some of mine goes over to him, and I like him. I know we have different chats, and maybe some is for this channel and some for the other. That's why it's the magic of YouTube. Everyone can make a channel, and everyone can find someone they like. Yeah.
The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment and information for each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged and committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or
Not shown
forced
on
doubt.
screen.
Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty.
I like
If
this
you have no
instruction.
reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to say and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and
nothing but
quality
reasonable
of the
doubt in this
evidence
case.
presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses.
I actually think that
However, if the testimony
they pay
of
more
such a
attention to
witness
this as I
convinces
don't think
you
they
beyond
read
a
it.
reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely
actually
on
think
your own
they're pretty fair.
conclusion about the credibility of a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. The verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. As I explained, the evidence goes back, the written instructions go back, and these verdict forms go back. And I'm going to go over them verbatim right now as part of my instructions. They're not complicated. You should find them quite self-explanatory, but again, to be thorough, I'm going to take a moment here to review them. There's 4 separate verdict forms appropriately labeled to correspond with each of the 4 counts.
But I think,
So I'm going to start with
I think there would be some
count 1, and you can see in big bold letters there it is.
Be some who
identified
will
as verdict
go
form
both
for
ways.
count 1. In
Hopefully
the upper
enough
left
saying
corner
not
is the
guilty.
date line when the jury has reached its verdict. The foreperson should put today's date. That's when you reach your verdict, which is January 25th, 2024. Right below the date line is the jurisdictional statement in the Circuit Court of the 16th Judicial Circuit in and for Monroe County, Florida Criminal Division. You will remember way back to jury qualifications, and we talked about everybody being a resident of the 16th Circuit, because in order to be a juror, you got to reside in a jurisdiction wherein the crimes were allegedly occurred and where the trial is taking place. So this tells us what the jurisdiction is. And then right below the jurisdictional information on the left is this, what we call the style of the case. State of Florida plaintiff versus Franklin Tyrone Tucker defendant, case number 2017 CF 841 CK. You've heard me say that multiple times. That's the case style and the case number. And below that is the heading of the form, and then there's 3 choices here. If the jury's verdict is we, the jury, find the defendant guilty as charged in the indictment of the offense of first-degree felony murder, the foreperson puts a check mark in the line ahead of that verdict, and then you see down here in the lower right is an area that says, so say we all, a line, foreperson. That's where your foreperson signs and then dates the verdict form. If the jury's verdict as to count 1 is we, the jury, find the defendant guilty of a lesser included offense of second-degree murder, well, then the check mark goes on that line. And then once again, signed and dated by your foreperson. And as to count 1, if the jury's verdict is we, the jury, find the defendant not guilty, then the check mark goes on that line and once again, signed and dated in the appropriate place. We've got a separate verdict form for count 2. This one's 2 pages. It's the same format, and I'm not, it's got the same information above the heading. And again, it's verdict count 2. So if as to count 2, the jury's verdict is we, the jury, find the defendant guilty as charged in information of the offense of robbery, then the line ahead of that verdict is checked. And then the jury considers the questions or interrogatories if it's guilty as to robbery. Obviously, if you don't find the defendant guilty of robbery, you don't go to these questions. But I'm going through the form in chronological order, not by any means suggesting what your decision will be, but only explaining it as it's presented here. So we see some instructions. If you find the defendant guilty of robbery, you must then answer the following questions. First question, in the course of committing the robbery, was Franklin Tyrone Tucker in possession of a deadly weapon? One of two answers, yes or no. Whatever the answer is, if you get to that part, that's where the check mark goes. Yes in front of yes, no in front of no. And you go on to the next question. In the course of committing the robbery, was Franklin Tyrone Tucker in possession of a weapon? If you get to this interrogatory, once again, yes or no, lines ahead of both choices. Whatever the decision is of the jury, that's where the check mark is placed. And then the final interrogatory on the second page, in the course of committing the robbery, was Franklin Tyrone Tucker wearing a mask? Same choices, yes or no, check mark in front of that answer that the jury unanimously finds to be proven beyond a reasonable doubt. So, if the jury's verdict was guilty and as to robbery, and you get through all those interrogatories, then the foreperson, again, this time it's on the second page, but it's again in the right-hand bottom part, signs and dates the verdict. Now, if the jury's verdict as to count 2 is we, the jury, find the defendant not guilty, so then there's where the check mark goes. You don't get those interrogatories, and you just have the foreperson sign and date the verdict. That's count 2. Count 3, separate verdict form, so labeled. Same format at the upper portion. Again, heading clearly says count 3.
Thank you, Bob. Good.
And then we look at the
Kudos to
choices
Baker
that
and
the
Jamie
jury,
for
the
all the
decisions
persuasion in this case.
available
Well,
to the
thank you
jury.
so much.
If it is, as to count
Yeah,
3,
it's
we, the
getting a
jury,
little
find the
long-winded
defendant
now.
guilty as charged in the information of aggravated assault, the offense of aggravated assault. That's where the check mark goes. And then you look at the instructions immediately below that finding, and you're told if you find the defendant guilty of aggravated assault, you must then answer the following questions. It's actually only one question. In the course of committing the aggravated assault, was Franklin Tyrone Tucker wearing a mask? Once again, there's yes or no options, lines in front of each one. If you get to this interrogatory,
No,
you
I'm here.
check which one of those two options the foreperson does. The jury so finds, signs, dates the verdict form by the foreperson. As to count 3, if the jury verdict is we, the jury, find the defendant not guilty, then the check mark goes in front of that verdict and signed and dated by the foreperson. Separate verdict form for count 4.
He's
same
sighing so hard.
heading, label, count 4. If as to count 4, the jury's verdict is we, the jury, find the defendant guilty as charged in the information of the offense of battery, that's where the check mark goes, ahead of that verdict. And then following the instructions, if you find the defendant guilty of battery, you must then answer the following question. In the course of
In
committing
Denmark, it's
battery, was
always the
Franklin
last
Tyrone Tucker
regular
wearing a
day
mask?
before the first. We
Yes
get
or
our
no?
pay.
Check the line in front of the answer that you find if you get to this interrogatory. As to count 4, if the jury's verdict is we, the jury, find the defendant not guilty, there's the line ahead of that verdict that's checked. And once again, if you complete the verdict decisions as to count 4, so say we all, signed by the foreperson, dated on the date.
Oh, he wants to go back and get a little pick-me-up in his office. In Denmark, it's just you always get your pay. Well, some people have every other week, but
A
normally
separate
it's the
crime is
last one day
charged in
before
each
the
count of
first.
the indictment and information, and although they may have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged, except as explained in the instruction for legally interlocking counts. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means.
Behave
Do not
yourselves.
contact anyone to assist you during deliberations. These communication rules
Let's
apply
see how
until I
you
discharge you at
think
the end of
about
the
this case.
If you become aware of
What
any
will the
violation
jury
of these
find and what do
instructions
you
or any
think?
other instruction
And
I have given in this case, you
54%
must tell me
says
by giving a note to the
the
bailiff.
jury will find him not guilty and you believe he's not guilty. And 20% says guilty and not guilty.
Many of you may have cell
Oh,
phones,
I was in the
tablets,
20%.
laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. And I'm going to explain a little bit more about how we handle that provision here in the 16th Circuit in just a moment. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. And that includes this unit.
Yeah, you got
here.
rich.
That's going to go back. Its operation is fairly straightforward. So if you care to view any of the video evidence, you'll be able to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So I'm going to ask attorneys to approach the bench.
Well, I actually think it was good jury instruction, and I like the way he emphasized beyond a reasonable doubt. He didn't do like we see in most cases. He just read through them like he was speed reading to try and get through it, even though he sounded like he was bored to tears in the end of it. Yeah. I like the way he presented this and emphasized beyond a reasonable doubt and what reasonable doubt is. Because most people are just saying beyond a reasonable doubt, and then it's over.
Remember back in jury selection when we talked about alternate jurors? And we heard from a couple of folks who served in alternate jurors, and I explained, I believe at that time, the importance of alternates and how I didn't relish by any means excusing alternate jurors because, as has been the case in this particular case, our alternates have been here throughout, just as attentive and patient and involved as
yeah, thank you, alternate jurors. Thank you, Danny T, for buttering my baker buns.
Because the first
I was working on my glutes yesterday. That's why my back is strong today.
The law doesn't allow
I was, Jamie.
12.
It was a bad day.
So
I didn't get
one
over
might ask,
880
"Well, why
pounds
don't
in
we go, Judge? I mean, you've been
leg
this
press.
gracious. We've listened all this
Oh my
time.
gosh.
We'd like to share our thoughts.
I have a
now
friend
that we've
who
spent
works
all this
on
time
an
here.
oil
We'd like to
rig,
hear what the other
and
think,
he's
and you're
getting
denying
paid
the
in
other
Norwegian
people.
money. He doesn't like it
Understand
when
that
he has to
feeling
change it to
entirely.
Danish.
All I can tell you is that more
Well,
often than not,
it's we actually had
trials,
someone
especially one
ask
of
about
this
it because we have a
duration, this number of jurors, things
masking.
happen where one or more of the first 12 are unable.
It's illegal to wear a mask, but
complete the
it
case.
wasn't there.
If we don't have an
You can't
alternate,
enter a
to
gas station with
sit
a
in
mask
that
on
very
or
seat that's
a
been
helmet on in
vacated,
Denmark.
we have a mistrial.
But you could
We've
do it
already heard
if it was a face
discussions about
diaper. You can do it.
how a mistrial is a waste of time and inconvenience on a
Yo.
cost and all the above. So we try to.
Oh,
avoid
they
that
make the
by
law and
getting
then they break
alternates.
it.
In this case,
I think Jamie
we
is
haven't needed
working.
them. So, with my sincere thanks, I'm going to excuse Ms. Van Stry and Mr. Amsterdam. Thank you very much.
They are about
Certainly
to send them back,
appreciate
and
your
then I'm
service
just
and
going to round
involvement.
up a few things, and then I'll send you all over to Dave's. If you want to go join Dave, I would. Mexican Law Show is one of the best channels on the internet.
So just a couple other things. I'm going to give those folks a moment to clear the jury
But thank you so
room.
much, Danny T.
Give a few further explanations about some of those instructions. I mentioned about electronic devices. You've heard lots of instructions about the prohibition about electronic devices, and it makes sense. In
Well-
terms of the prohibition against having access to the electronic devices,
Oh my
personal
God.
devices, that's an administrative order from the Florida Supreme Court. That's not something that yours truly has concocted on his
Because
own.
some
That comes
judges
from
are
the Florida
stupid.
Supreme Court, and of course we honor their
Did he say
authority and
yours
their rules and
truly?
regulations. But here, instead of having you leave whatever devices are on the seats there, we have what's called a lock box in the jury room. So you bring them in there, bailiff will be in there at that time, present whatever electronic devices
It
you may
happens.
have.
I've
Right
heard
before your
them
very
use
eyes,
them
they're
first and
placed
last
in the
name.
lockbox. It's
Can you please call
secured.
Mr. Blah
There it
Blah Blah
sits.
back in here?
So I think that gives people
Morning.
a little bit more security and assurance that their devices aren't going to be compromised. Not that they would be, but just in terms of state of mind, they're right there. And when you're finished, they're there for you to repossess, to take again. So that's how we do that. You will be able to take your notepads with you now. If there is some question, problem, communication that you believe is needed with the court, then your foreperson should take a clean page, nothing with any kind of marks on it, but a clean page, and in legible, complete, comprehensible fashion, write or print whatever it is you want to ask me or tell me. Judge Jones. Then, when it's complete, the foreperson should put his or her name,
I like him.
fold it in half, knock on the door, give it to the bailiff. The bailiff will alert me, give it to me. I'll look at it. I'll share it with everyone, the lawyers, and I will do my best after receiving input from them to provide an appropriate answer. So, the alternates gone. Ladies, gentlemen of the jury, you may now retire to consider your verdict.
Well, while we wait, this is the famous treehouse. It's one of the only pictures I can find of it online. But this is where Paula stayed and where they ran a prostitution ring out of, and a little rock slinging. So it seems, yeah, I wouldn't stay there. But again, the hurricane had just hit, so people were probably desperate to sleep anywhere with a roof over them. I found a fascinating article as well Lead detective claims his boss coached witnesses and fabricated evidence.
Here, after securing the electronic devices, I'm going to give him the
I haven't seen
verdict forms.
anything on Twitter from
instructions.
Grant Boy.
Then I'm going to have him
Couple of
One of
hours,
the
I think. A
security
couple of
officers.
hours.
take all the evidence, bring it back, knock on the door, present it along with this device.
What
to
time is
view
it now? It's
So whatever
10:15. They could be back before lunch.
Which you probably already have, but when I step down here, if
Not
Tucker,
inside
the
it.
state
It's
wants
on
to
the, as you can see here,
examine the
it's on the steps up to it.
there, and similarly, everything, if there's anything that's there that shouldn't be there, then it doesn't go. Doubt if either one of those is the case, but just to be sure.
I will
Then,
be back for the verdict. Of course
we
I will,
mentioned
but instead of
yesterday,
me sitting here paddling for a couple of hours, I'll send you over to Dave, and
as long as there's a means to contact
and you can watch the Crumbly case. In your opinion, was this a decent case? Did Tucker do a decent job in poking holes in the state case or presenting his own case? It wasn't a decent case.
Just as soon as we, finish our
There
immediate
was
business,
I don't understand why they.
I'm going to be conducting, and of course,
I don't understand why they brought this case against him. I see no evidence linking him to this trial or this murder. Then the other question, did he do a decent job in poking holes in the state's case? Yes, but his problem was he had too much focus about everything else than this case and the important job of poking holes in the state's case. He spent way too much time to try and talk about everything else. And to me, that's the biggest problem, because had he been a trained lawyer, or had been, I wouldn't say competent, but had he had the skills necessary, he, as I wrote yesterday on when someone said I didn't like him, or I found him that he was guilty because of something. No, I had 4 points that I put down. Number one, you got the lead detective to admit she couldn't recognize him on the videotape. She just says it now because Travis says it's him, but there's no evidence that it is him. 2, Travis took a 5-year plea deal, and he got him to admit, I would do anything to stay out of prison. Then we went to lunch, and then he went on for 3 hours talking. He shouldn't have done that. He should just have said, so what you're telling me is you were offered a 15-year plea deal. That was turned down to a 5-year plea deal, and you took it because you wouldn't be in prison for life, correct? Yes. So you were willing to do whatever it took to stay out of prison. And they would probably have objected, but no matter what, you would have put it in the jury's head, and you would have ended on that note. Boom. You would do anything to stay out of prison. Then the DNA evidence. I would have stood up and said, of all the evidence found at the crime scene, was any of my DNA found anywhere? And they said, well, it wasn't conclusive. So if it's not conclusive, does that mean none of my DNA has been proven to be on the crime scene? She would have to say yes, or she would be lying, because inconclusive is the lack of evidence isn't evidence. So you can't say, well, it's probably there. That's the 4 points I would have hammered home, and I would have done it way shorter. My closing arguments, I would have stood up, said the same 4 things, said, members of the jury, as you remembered, I had 4 cardinal points in this case. 1, the lead detective clearly stated She can't recognize me in the videos. She just said it because Travis said it. Talking about Travis, he admitted under oath he would do anything to get out of a life sentence. So how far would it be to believe he was willing to point the finger at me just so he could be framed as the getaway driver instead of being a culprit to the murder? He went from a 15-year plea deal to a 5-year plea deal, and then he knew my name. That seems a bit suspect. 3, none of my DNA was at the scene, was found at the scene, was found at the murder weapon. Again, the murder weapon was placed in my hand by Travis, a man who took a 5-year plea deal to get out of murder. Oh, I forgot number 4. The surviving victim said it wasn't me. She said she heard the voice, she noticed the person. It wasn't me. She's on her deathbed, and before she went to her grave, she asked me to make sure you knew it wasn't me. I know it wasn't the best interview. She was very sick, but she wanted you to know it wasn't me. Adios, amigos. That's what I would have done. Done it in 15 minutes. Get out of there. Ciao, baby. Just got here. It's just been turned over to the jury. Boom, 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 boom. We all travel as a pack. Dun, 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 dun. Jamie is giving me a work break. Yeah. Oh, she showed up just as I'm about to go. Can you go
Yeah,
over the
that's fine.
article quickly before you go? Sure, I can. I have nothing better to do. It's just there's a new ripple in the three. I can't. That word is so hard for me. Treehouse murder case. In a deposition, the lead detective claims his boss at the sheriff's office has coached witnesses and used fabricated evidence in building a murder case against Franklin Tyrone Tucker. Blah, 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 multiple times. Blah, 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 blah. The problem with the version of the facts is there are 2 victims who did survive the assault, Paul Belamonte and Todd O'Quinn, and they both knew Ty Tucker and both insist to this day he wasn't there. I must have told the detective probably around 10 times that it was not Tucker, said Paula in her September 28, 2020 deposition. Did she know what Tucker looked like? They were friends. The two had breakfast together 3 or 4 days after the incident at McDonald's. We know this from this trial. Around the treehouse, people have their own theory of what happened. A feud between 2 women has caused the death of an innocent man, old Matthew Bonnet. The women are Paula Belmonte and Anathea Clay, both believed to be informants for the sheriff's office. A number of people came forward to detectives, including Paula, saying Anathea organized the heist, which turned into murder. The status of the treehouse itself is somewhat of a mystery. Every member of law enforcement who responded to the murder that night seemed to know that Paula Belmonte was dealing drugs in her makeshift apartment on the treehouse roof, yet we found no records of drug arrest at that location for the 9-month period just prior to the night of the murder. And confirmed confidential informant told the Blue Paper that the sheriff's office had been working the treehouse. Some puzzling details has emerged. A marked $100 bill was found flopping around at the scene that night. An officer is heard saying, "Oh, it's mine. You check the serial numbers. If it ends in 27, it's mine. 27A, something like that." The number ended with 72A. On a recording of an open mic at the Detectives Bureau, Captain Penny Phelps is heard, that's the one who got thrown out, warning the other detectives, "I hope Todd O'Quinn can ID him, otherwise, Jesus Christ, we are all in trouble." Him was Ty Tucker. Phelps does not elaborate further on what kind of trouble was lurking over all of them. Matthew Pitcher, the lead detective in the case, was reasonably deposed by Tucker's attorney, Kara Higgins. Higgins asked questions about the controlled buy gone bad theory and why there's a sheriff cruiser parked across the street around the time of the murder. Detective Pitcher denied knowing anything about a drug operation that night. However, some of Pitcher's responses do raise questions as to the integrity of the investigations and whether an innocent man living at the Cots homeless shelter at the time of his arrest was somehow turned into the treehouse murderer. According to Detective Pitcher, Captain Phelps decided to arrest Tucker for Bonnet's murder after she found that he looked the part in a fantasy fest photo. Kara Higgins, and did she show you a picture of Ty Tucker in the makeup holding a toy knife? Yes. She pulled it off his Facebook page. Yes. And it was a recent picture? Yes. Fantasy Fest in the end of October? Yeah. What did the picture show? Just his face and him holding a knife. A fake knife, right? A plastic knife, as far as I could tell. And he had makeup on his face, right? It wasn't a mask. No. So Daniel Malone and Penny Phelps make a big to-do over his Facebook post, don't they? I can't recall if it was a big to-do, but definitely they were excited about it. They were excited because he wore a costume on Halloween, right? Yes. Okay. So based on that information, they determined he was a suspect, right? I believe that played into it. Yes. Played into what? You didn't have anything else. Correct. Are you okay with that? Are you okay with them developing him as a suspect because of a picture on a Facebook page for Halloween? I would not say suspect, a person of interest because of the fact he has also been walking with Roy the next day. Note, Roy Wilson is a co-defendant who was recognized by Paula Del Monte and Todd O'Quinn as one of the aggressors. Tucker was seen with Roy 2 days after the murder at Metro PCS, paying his phone bill. Are you aware that Danielle Malone testified under oath that she had not seen that picture nor showed it to anyone? She wasn't made aware of it until months after Ty was arrested. I didn't know that because that's a lie, isn't it? She showed me a picture. During the deposition, Detective Pitcher revealed that before finding the infamous Facebook photos, the investigators had no evidence against Tucker. Okay, at that point, when you are executing a search warrant, the only information that you have about Ty Tucker is that he walked to the store with Rory Wilson to pay his own cell phone bill and that he dressed up for Halloween. That is correct. And again, you had no evidence. Correct. Nothing correct. So he was guilty by association. He was. He became a person of interest or suspect because of the association. Do you think Penny Phelps acted properly throughout this investigation? No, obviously. She was released for one thing. Detective Pitcher said it's for a jury to decide whether Tucker was involved or whether he is the murderer. But Pitcher also claims that Captain Phelps coached and directed most of the testimony for the prosecution. It didn't matter to Paula Belmont that her attacker wore a mask. Through his body language, Swayzer, and the sound of his voice, Swayzer, she recognized him instantly. Rory Wilson, a black man also known as Detroit. She reported it to the detectives that very night. Captain Phelps, however, pursuing a different angle. In a recorded interview, Captain Phelps tells Rory Wilson that she believes he's a good, decent man and a victim of a murderer, Ty Tucker. So you didn't do it, and I know you didn't do it, but I know Ty did, and I also know this, Rory. You were there, and there's that two sides to the piece of paper, and you get this one chance to tell us your side of the story, Rory. One chance. We are all you got right now. Rory, you didn't kill anybody. I absolutely believe you. You didn't, but you were there when somebody died, and it was an accident. No, you got to take that with Ty. I'm telling you, I can't just tell you. Make up nothing. I guess, all right, okay, just like me, I just say, hey, he done it. I get to go home if I just say, yeah, Tyrone done it. At this point, the recording stops. All the tape was later edited. Nobody seems to be able to answer why there are 3 minutes missing of the recording. Did Captain Phelps make some promise to secure Rory Wilson's testimony against Tucker? When the recording resumed, Rory had a change of heart. He will now endorse the Tyrone did it version. He just doesn't want to be known as a snitch. Kara Higgins asked Detective Pitcher what happened to the missing 3 minutes. That I don't recall, and I don't know what I should say. Did you ever look for it? I believe IT was asked to see if they could come up with it. Did they find it? No. Prior to Captain Phelps coming into the room, did Rory Wilson make any incriminating statements about Ty Tucker? No. So Captain Phelps comes in and she tells him what to say, doesn't she? She gives him a path to go down, right? And she tells him what to say, right? Yes. Were you concerned that she was feeding Roy Wilson a story? Yes, I did not care for that interview. Reading this, I I don't know why it's not allowed to be brought into the trial, but that could be fun. We are at Verdict Watch right now. I just read an article I found from 2021. Lawyers know when to object and when what motion. Yeah, and how to argue a motion. That's the big problem. Be back for verdict. Yeah, everyone should be. Charge to the jury took 49 minutes. Or the jury instructions, 45 minutes. Yeah, probably around that. It was not that quick, but it was well written, read to them. The state definitely made inconclusive sound as it showed guilt. Yeah, and that's wrong. I don't. My only tree on my in my garden is roughly that high. I probably couldn't build a tree in it. I'll get a bird tree in it. Hey, howdy, buddy. 2 streams up, so many two lawyers these days. Well, I'm not a lawyer. Oh, is Judge back? Or was it just? Oh, it's just nothing. Will you be back? I will be back for the verdict, yes, but I'll send you all over to Dave, and if you follow me on X, I will put up when I come back for the verdict. My poll says around 50% believe that they will vote not guilty. So I believe he's not guilty. I'm afraid they will vote him guilty in a lesser included. Penny person was, I believe she was the one who took the stand. There was some of them. No, the lead detective wasn't. There was something wrong. She couldn't be called to the stand. They objected to him mentioning her yesterday. I don't know why. Well, I should.
Yeah.
Well, I've been wrong before, but luckily today I can send you somewhere else, so I don't have to sit here for 35 hours. I think Paula will work against him with the jury because he was way too friendly with her. Yeah, and they got. If they caught on to that Disneyland trip, it could be a problem. Could be a problem. 54-44. Yeah. I watched over on Law and Crim, and they actually, I think they had 40%, 47% not guilty. That's the first time I've ever seen it. Yeah, it's a great article. It's this case is so shady, and it's just too bad they couldn't bring that in there. But yeah, this should never have been brought. Absolutely no way. Yeah. Yeah, reading this, I now know why he wanted to bring all of that in, but when it's not allowed, don't waste time on it. Well, let's ask. We have some locals down there. Is this known in the local community so the juror might know of this, even though they are wardered and says, I don't know nothing? Is it known down there what is alleged to have happened around this case? Never confirmed. It's not confirmed that she was a undercover thing for the police, and yeah, she was the victim. Well, the state claims she changed it because she didn't say the same thing on the night, but again, she clearly said Ty Wilson, Rory Wilson on the night of the murder, and apparently they didn't find him. As a suspect. Probably because he looked the part. There must have been some pre-trial motions we don't know about. So much corruption everywhere. Yeah. Totally sketchy. That's my big problem too. M. Jung, that's why the people who live there, it could be interesting to see how much of this is common knowledge. Yeah, but there will probably be, I don't know what pre-trial motions have been in this case. Hey, Anne. How are you doing today?
Hey,
Yeah, this
Ian.
was weird, and that she's at a medical care facility that costs $6,000 a week as an old crack addict, as a little one too. No, absolutely not. He won't last 4 years in law school when he can't shut his mouth for 2 seconds. He kept talking over the judge, even though he was reprimanded the very first day. He could never sit through law school. I think he has ADHD or something. If he's acquitted, I think he has a civil suit against the state. So taxpayers, you're gonna pay up probably. Your favorite law tuber is in MLS chat. No, I'm here. Well, I'm not a law tuber. I'm a lay tuber. Hey, Junior Mass. I don't know if it's Junior JR, but I'm just saying it. But nothing is happening. Jamie, will you keep an eye on the account that has me blocked and tell me if there's a verdict?
Yeah, I'll keep watch.
Yeah, if I did it, I would too. I should write a children's book. Sell that to make money to go to Dollywood. Maybe about a little baker and his grandma who taught him to bake. Because that's my story, Jamie. Couldn't that be fun? Maybe color in so you could read it for your kids and they could color the. Jamie, I'll work on that idea.
You better. That sounds amazing.
Well, I'm a lay tuber, not a law tuber. People know. Oh, that's good to hear, Laurie. Yeah, because even though in Wadir they will say, no, we know nothing about it. It's been going on for 7 years, and it's been blowing up everywhere because of all the internal investigations and stuff like that. So people will know about it.
Yeah.
You'll let it slide. Thank you so much. Yeah, I'm blocked by a reporter from Law and Crime. I never talked to her, never said anything. I went to see on the verdict watch, and I'm blocked. So, yeah. I just no, because Dave is not blocked, but I think it's because when you stream, that's their way to hit you because they can't copyright strike you. But everyone, go over to Daddy Dave and say the Danish
Dave.
Viking cartel sent you, and hopefully you'll be back. I'll put it on X when I make everyone mad. That's my specialty. But I'll put it on X when we have a verdict, and I'll start a stream up so we can watch it together, or watch it if we're a bit late on replay. Thank you all so much for showing up. Say hi to Dave, and I might jump on over there at some point. Hasta la vista, baby. That means see you later, baby. Maybe. I don't know.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor. 100. Because it is 100% correct.
Objection, Your Honor.
You see the lawyer's face? Okay, we have to go back and they.
Widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
Wait a minute, I need this story time.
Everybody has.
Everybody has.
Everyone has slept with his mother.
If I showed you.
Oh my God.
I'm having a Jamie moment. And the way he just said it, he was just like, everyone had things on YouTube.
Mr. Randolph, do you?
I got to get some man. You don't know.
Called him chicken shit.
That's right, you was chicken shit.